Hello again, Bradley Courts here to talk to you about student loans within a bankruptcy. I know I discussed this earlier in another one of our videos, but one of the big issues is whether or not this can be discharged. Section 523, subsection A, subsection 8 deals with bankruptcy and student loans. Also, this is folded into the Chapter 13 area through a combination of Chapter 13, Section 1328, subsection A, subsection 2. I know that's very technical, but it's important to remember there are two kinds of bankruptcies. There's a Chapter 7 discharge, and there's also a Chapter 13 discharge. And through a Chapter 7 is basically a so-called fresh start where you take and wipe out almost all of your debts. A Chapter 13 allows you to pay some of your debts back, and at the end those debts that qualify for discharge are then discharged. I know it's a little bit confusing, but some of our other videos explain sort of the differences between Chapter 7s and Chapter 13s. Now, in a student loan context, as I discussed in my earlier video, it is very difficult for you to have a student loan discharge. One of the key issues to look at is whether or not it's a qualified educational loan, and that is looked at under Section 221 sub D sub 1 of the Internal Revenue Code. And if it's solely to pay qualified higher education expenses, it's generally considered a debt that is a student loan and can become non-dischargeable under, as I discussed, 11 USC Section 523 subsection A, subsection 8. When they are determined to be undischarged or non-dischargeable, rather, what are some of the things they look at? Well, one of the things they look at is what is this debt for the cost of attendance to a higher educational qualified institution, and that is a very broadly described debt. It is broadly defined. Also, the eligible institution issue involves Title IV programs that, in essence, are able to accept federal financial assistance programs. There are some schools that don't qualify for that, and that is something we need to see right when you come in. We need to have you describe the school you're in, bring the information about the school so we can look at it to see if it's a qualified institution. Most are. I mean, your average school, the University of Memphis, obviously would be. Schools of that stature are easily defined within the Title IV program. However, there are some schools that are for-profit schools. They have other issues. They may have been in and out of accreditation, etc., that may not qualify under Title IV. Those possibly could be dischargeable. Again, those are some technical issues that we need to look at. So, maybe you may hear that student loans are impossible to dismiss, but what you need to do is have a lawyer look at the whole picture and let us look at all the facts and then apply the law, which I've just barely touched on today, but to give you a sense that it is difficult, but it will require your attorney to look at it within the context of your bankruptcy to see if you would possibly qualify for one of the exceptions to discharge. They are hard to obtain. They are brought through what's called an adversary proceeding, which is a separate complaint that you file within the bankruptcy to determine whether or not you would qualify under what we described in one of our earlier videos as the Bruner test. And we look at that in one of the cases in the Sixth Circuit is In Re Oyler. It's Oyler, and that's found at 397 F. 3rd 382. It's a Sixth Circuit case that basically describes the Bruner test for our jurisdiction here in Tennessee. So call us, come see us for an appointment. We have attorneys on staff that can file for you if you live in the jurisdiction of Tennessee, and also an attorney here that files for individuals that live in the state of Mississippi. So we look forward to talking to you about your bankruptcy issues, and especially student loans. Thanks again.